The United States never had a doctrine of judicial immunity from prospective relief. When you look at that thing called the Bill of Rights, which is your sovereign immunity, you see that I always say that privacy is the core and backbone of it. Privacy, in short, just means to be left alone. To have the right to just be yourself and do what you ought to do privately without being bothered or anyone else intervening in your affairs. Injunctive relief does that. The only way, sadly, that most people know injunctive relief is at law to say, hey, child support, let me go file some quick little form of document in the courthouse to prevent the father from seeing the mother or the mother from seeing the father. Just things like that. People use it against one another. But you're supposed to use it equitably against governmental actors also. Does judicial immunity protect a member of the judiciary acting in her official capacity from paying attorney's fees in civil suit? So it's attorney's fees, you can claim it also even if you're not using attorneys. Cost that the other party was liable for. This cost that the other party was liable for is that private contract that many people run about by doing that default judgment stuff. Quote, all other relief other than compensatory money damages and thus include injunctive relief. Hello, beautiful people. Judicial immunity, 11th Amendment, injunctions, declaratory relief. Those are the subject matter we're going to speak of in this video. Initially, I was intended to create this video just for patron members, for the sole reason that in the prior meeting, we spoke about something called prosecutorial immunity, which is an offshoot of judicial immunity.
Immunity from 1983 suits for damages when he acts within the scope of his prosecutorial duties. These courts sometimes have described the prosecutor's immunity as a form of quasi-judicial immunity. In other words, it's telling you judicial immunity is a separate type of sovereign immunity, whereas prosecutorial immunity is one of its own. Therefore, prosecutorial immunity, since it's dealing with judicial-related matters, it's quasi. Then they can share some of the judicial immunity, but they're not really acting judges. But they can still be immune because it's dealing with, judicial determination, and refer to it as derivative of immunity of judges recognized in Pearson versus Ray. So if you want to know about how judicial immunity came up, this is the case law right here, Pearson versus Ray.
But I realized the solutions we're about to speak of here and the foundational principles of what makes this work, the origin of it, and the thinking behind the issue and the thinking behind the solution is more applicable to a larger range of audience that might not have the privilege to be a patron member. So listen very carefully and pay attention. The same case law, Pearson versus Ray, which is one of the deciding factors from the United States Supreme Court that gave rise to judicial immunity. I say one of because functionally the origin of any type of immunity, qualified immunity, prosecutorial immunity, or judicial immunity, is an offshoot of something called a sovereign immunity, which was originated in the 11th Amendment. We went over that in this video. So this case law regarding judicial immunity, we're going to go over it here. The focus of what we're really going to go into as it pertains to what that judicial immunity does not cover or what it does not apply to. The secret to it is found in Pulliam versus Allen. What that judicial immunity does not cover or what it does not apply to. The secret to it is found in Pulliam versus Allen. And it's two things that many people are readily aware of. As it's always said, many people know about certain words and certain things. How it applies, why, and the thinking behind it, and how they apply it is what they don't know. We'll begin to clarify that here. So we'll touch on the origin of judicial immunity as it pertains to res judicata, aka the interpretation of the legislature by the Judicial Department of United States government, which most people loosely refer to as, quote, judge-made law. Even though we all know acting judges do not make law, the legislative department does. They just interpret it. But we all know contract law is based on stipulations whereby people are bound by, and decisions of court cases on a Supreme Court level are binding decisions. And based on contract law, when a binding concept or principle applies to certain parties, then it's a law of its own. That's where you hear the maxim or the verbiage, the contracts makes the law. So people just shorten that to the phrase judge made law. So we'll be going over that judicial immunity a little bit here, but more so focus on what you can do to alleviate any type of bound and meat that limits your own substantive rights. Because this thing called judicial immunity is basically protecting them while they are under their own capacity. Granted, if you can prove and show that they were acting outside of that judicial capacity, obviously judicial immunity does not apply. But the way judicial immunity or any type of sovereign immunity is applied in today's world is it's used as a bar to prevent a claim or assertion on a private capacity of the one role playing wearing some type of costume. Which brings us here. How do you alleviate that if the assertion against you, the everyday man, is, well, I was just doing my job? There are certain things that even if they make that assertion, you can still assert successfully if you know what your sovereign immunities are, the elements, standard, and test, and those manners of enforcing those sovereign immunity of yours, that even if they are claiming, hey, I'm just doing my job, aka judicial immunity. Hey, I'm just doing my job, aka prosecutorial immunity. Hey, I'm just doing my job, aka qualified immunity. Two things apply nonetheless. It's called injunction and declaratory relief. A good amount of those seeking special information somewhere, or joining some special group, or claiming some special status, are well familiar with those words. Why they are familiar with those buzzwords and its usefulness, chances are it's likely still not clear yet. But don't worry, that's the reason why this is being placed on YouTube rather than on Patreon. Now, before we go over these res judicata, a few caveats. The first is, in many videos where I go over res judicatas, I always mention something about the case not being overturned and that there's a website you can look at it. For those who have yet to find it and are sending messages asking what am I referring to when cases are not overturned and you can look it up, here it is. It's called constitution.congress.gov. I'll put the link of it right in the screen over here. /resource/decisions-overruled/. In case the hyperlink or the webpage gets altered in the future, for those listening to this in the future, just go to constitution.congress.gov. Decisions overruled by subsequent decisions. You will see a table that has a search bar embedded into it, starting from the earliest point to which res judicatas are preserved on a congressional record, which is 1798, up till the current year. You can even filter it as you desire. So for instance, let's use these case laws we're going over. So usually when I go over these in videos, I know that they have not been overturned because I've done preliminary basic research before coming out here and making these videos. But when I mention that, oh, hey, it's not been overturned in Supreme Court, it applies to everyone, apparently some people are somehow still a bit confused about it. Let's just take this opportunity to embed that guide in this video before we continue. Whatever case law you're looking for, type it in there. So what we're going over today, Pulliam versus Allen, if you don't find any matching result, that means it's not been overruled, because this search function exists to show you specifically res judicatas that has been overruled. If there is no matching description in this search bar, then that means it's still active, still applicable, and usable. Now, if the second res judicata is Pearson versus Ray, just copy that and paste it. No matching records found. So that means it's still active and applicable. The next question you ought to ask when it comes to applicability of res judicatas, which in most videos I make it almost a mandate, no matter how repetitive it is, that hey, look, this is from the Supreme Court, so it applies in all 50 states. And in videos whereby certain res judicata is shown where it's not on the Supreme Court level, and it applies to a certain district, I let you know, look, it applies to this district, so go look it up. Now, in some cases, if it's on an appeal level, it applies in all that state, since it's an appeal level for that jurisdiction. But if it's a federal district appeal rather than United States, so there are hierarchies, trial stages, which is the district court, federal level, and then there's appeal for those trial stages, which applies to all the circuits. Here's what circuits look like for federal level. This is an image that's conveniently found all over the internet. You can just use a basic search engine and it will bring this up. So when you're reading the rest of the card, it shows the 4 appeal circuits of United States District Court. Well, that means it only applies to Virginia, North Carolina, South Carolina, West Virginia, blah, blah, blah. Whatever geographical bound, aka venue, which that court issuing that decision as part of its district is where it's applicable to as mandatory res judicata. If you were, say, in the 8th district, meaning a different venue at South Dakota, and you cite a res judicata from the appeals, not the Supreme Court. Now, it has yet to move to appeal. Remember, on the federal level, there's district court, there's appeal to those districts, which is what you're looking at here. This is the 1st district, 2nd, 3rd, 4th, so and so. After the appeal for those districts, which combines a few district courts together to appeal the decisions around that area, then comes the United States Supreme Court, which is evenly applicable to all these different venues. But if it's just a decision or res judicata at a given appeal from the 4th district, but you are South Dakota, which the venue is different and classified as 8th district, then it's called a persuasive res judicata, which is the 2nd criteria now. So you know that it hasn't been overruled using the website. The second thing you have to find out is it mandatory or persuasive. What is mandatory or persuasive res judicata? Here it is. Mandatory authority. Courts are required to follow the decisions of higher courts in the same jurisdiction. Venues also determines the power and applicability of jurisdictions. If you ever watch movies and some entities go to the other and they're telling you, oh, this is outside of your jurisdiction, they're speaking about bounds, territorial claims. That stuff animals do where they piss in areas and then their marks, it's the same as their scent, and then another animal goes over there and smells it and realizes, okay, there's another animal here. Well, humans do that, but they just do it in a more sophisticated manner. And in short, it's really the same concept. And each of these different courts are really on the back end administered as one, but nonetheless, they're given their own independent power to make certain decisions because of certain ancient laws that once existed. If you look at that same map we just looked at, those boundaries at some point did not exist. Some were subdivided according to Spanish law, some were subdivided according to English law, some were subdivided according to Portuguese or French law. And some of those old laws still have some type of effect one way or the other. And it was not able to be finalized as to how they would make certain decisions in certain geographical bounds, even though it's generally accepted to use British common law as some of the foundation in North America. But nonetheless, some of the old boundary situations still stand, and they divided it accordingly. When you see that map we just shown, that division is not coincidental or random. It has a lot to do with how things came about before 1798, which was where the judiciary started to hear its cases and things like that. But that's another video for another day. So when you go to these different boundaries, and the res judicata is from that given venue which establishes jurisdiction, it's called mandatory authority. And what is mandatory authority? Courts are required to follow the decisions of higher courts in the same jurisdiction. It's a requirement. Accordingly, cases which are both one from a higher court, meaning automatically the Supreme Court is applicable anywhere, and two in the same jurisdiction are considered mandatory authority, which brings us back to this image. So if you're South Dakota and you're citing a res judicata that's not necessarily the Supreme Court, but it's still on an appeal level or a district, aka trial level, from this same geographical bound, aka venue, which highly plays a role in determining jurisdiction, then it's mandatory. What if you're in this same South Dakota and you have a favorable res judicata from the 4th, 3rd, 1st, or 2nd or 6th District of Appeals? Can you still cite it? Absolutely you can. but in said case, it's more so persuasive. While it is always best to cite to controlling authority, aka mandatory, sometimes it can be useful to cite non-binding cases as a relevant persuasive authority. For example, if there is a little or no binding authority for your issue in your jurisdiction, you may want to cite to on-point cases outside of your jurisdiction. When citing cases that are merely persuasive rather than binding, aka mandatory, aka required to follow, it is important to explain why the court should follow the precedent. In short, it should always go back to constitutional intent of the legislature, because the judiciary is meant to interpret the intent of the legislature. That is the highest reason why a persuasive res judicata, aka persuasive authority that you're citing from a different jurisdiction or a different court, can really pass in any other court, just so you know. But they give you some examples. Such explanation may include, although the court in question has not decided the issue, every other court that has heard the issue has come to the same conclusion. The reason why they will do so is because of the intent of the legislature, the Constitution. The decision from the other court is based on statutory language, public policy consideration, etc., identical to what is an issue before the court. In other words, similarity of the specific circumstance you're dealing with. 3. The decisions from the other court is factually indistinguishable from the court case, and or the other decision is most recent authority available on the topic, meaning there is no other decision in a similar jurisdiction. Simple as that. It then goes on when it comes to the mandatory authority to give you what we've already basically spoken of. But just so it's not just me saying it, well, here it is in black and white from a third party. All courts, federal and state, are bound by the decision of the United States Supreme Court on the U.S. Constitution and other issues of federal law. I assume most people listening to this already know that. In the federal courts, circuit courts tend to follow decisions previously issued within that circuit. I assume at this point you already know what it's meant here when it says within that circuit. You've seen it. What it's meant here when it says within that circuit. You've seen it. We've shown the map. Moreover, each district court falls under the jurisdiction of a circuit court, and the opinion of that circuit court will be binding in that district court. Now, with that short opportunity for that clarity to be provided for those who need it. Pulliam versus Allen. Docket number A2-1432. The lower court it came from is the United States Court of Appeal for the Fourth Circuit. This case was decided and later pushed up through the Supreme Court via certiorari. So appeals of those circuits are keys to enter into Supreme Court. Decided by Burger Court. In case you're wondering what Burger Court is, it's not a location. It's just more so the period of, I believe, 1969 to 86, where Burger was the last name of the Supreme Court justice. So court is usually a term used to refer to anyone who is sitting in a position of an acting judge. So you hear them, instead of saying Judge John Doe, they will say the court. So Burger is the last name of the Chief Judge of the Supreme Court at that time, and court is what they used to refer to acting judges. And where you see the fact that it's referring to lower court means it was moved up from this Fourth Circuit. So this decision was made by the Supreme Court during the time where the Chief Justice was Warren Burger, hence Burger Court. Argued November 2, 1983. Decided May 14, 1984. So what are the foundational facts behind what even gave birth to the fact that this thing called injunction and declaratory relief can be used against acting judges even if they decide to claim judicial immunity? Fact of the case. In January 1980, Richmond Allen was arrested for allegedly using abusive and insulting language, which is a Class 3 misdemeanor with a maximum penalty of $500. So this guy was basically brought into a suit because, well, he used insulting languages, and we went over the fact that freedom of speech does not apply if it's for the purpose of inciting fisticuffs, aka fighting words. In other words, anything that disrupts public peace. Now, whether or not he asserted First Amendment speech, that's not what we're going over here. But nonetheless, they brought him into a suit and said, look, the maximum, meaning the worst case scenario is you're going to have to pay $500. Okay, cool. And that's Richmond Allen. Gladys Pulliam, the state magistrate for Culpeper County, Virginia, set bail at $250. And when Allen was unable to make bail, Pulliam committed him to the Culpeper County Jail for 14 days. You know how many people this applies to today, now, as we speak? Non-jailable offenses, they're just throwing them in jail. Whether they formally sentence them or not, they're just sitting there, awaiting trial, sitting there, awaiting trial, sitting there, awaiting trial. For a non-jailable offense, now, it's completely different. If something was committed that's jailable, and even then, you still have some stance and contention, which will be a bit different. But many people, such as things like basic minor traffic tickets, that's non-jailable. They put them in jail for 3, 5, 6 months. And even in some circumstances like child support, people just sitting there awaiting trial, sitting there awaiting decision. Well, same applied with this guy named Richmond Allen by the hands of magistrate Gladys Pulliam. The trial judge reopened his case, Allen's case. So by the time it went to trial stages, Pulliam, who was a magistrate, of course, cannot hear the final decision of the case. They're most of the time there to determine probability of a crime being committed. But of course, they get power hungry because most of these people who are in positions are still little children wearing costumes or just looking for a way to exercise some power, and they're looking for the most dumbest, ignorant man or woman in society to exercise that against. So they can feel that short gratification also, even though it's always going to forever be void. But nonetheless, the everyday man still suffers for it. Why? Because the everyday man does not know what belongs to them rightfully and what doesn't. Which brings us to this video, because what's been happening since the 1980s is still occurring now. Goes to say nothing is new under the sun, and it's up to you to make a change to what you say is your right. The trial judge, again, different from Gladys Pulliam, who is just a magistrate to just hear probability of the case being an offense or not. The trial judge, who is now different, reopened his case, his Ben Allen, and reversed the judgment. And this is despite the fact that Allen has been in jail for 14 days. Allen sued Pulliam, who was not the trial judge, but the one who initially threw him in jail for 14 days. Allen sued Pulliam in district court and sought declaratory and injunctive relief for incarcerating him while waiting for trial on non-jailable offense. So people want to bring damages. As we went over in that patron clip I just shown, damages are not assertable when it comes to any type of sovereign immunity, whether it be judicial, prosecutorial, or qualified. But guess what? Certain things are still applicable. You still want to assert certain claims? It's called declaratory relief. Which now brings us to the fact that many people do this thing called administrative process, and it's been drilled in their mind so much that, look, once you just send them this notice and you send them notice of default, you got them. That's it. Oh wait, now what? This is where you find many people start running saying, hey, these people are in default, they gotta pay. They're in default. They owe me money. Yeah, all right. Okay, cool. They're not even going to go up to the point to assert judicial immunity because, one, they know you can't sue. You can't sue because you don't know how to. So some people say, hey, file Title 18 against them, but the concept of sovereign immunity disallows Title 18 unless you use an attorney. In North America, to bring criminal claims, and attorneys have to be used. In short, civil claims, you can do that yourself. But the contradiction to most people is, well, you did that thing that you say it's a contract because you just sent a one-sided document to them that they did not respond to, and thus you send what you consider a default. Okay, cool. That's a contract, right? But where's the assertion of criminality involved, and how does that give rise to criminal activity? That's the question you should be asking. If you're revoking a contract, how did it give rise to a criminal activity? And most importantly, if you're going back to the source of what caused you to start doing that contract, well, is that contract enforceable? for the source of activity that you're saying is the criminal activity to be viable. Do you know the standard test and element to those criminal activities? And do you know that those criminal assertions and suit that you're trying to bring requires an attorney?
I want to say, although Bay states that he brings this action pursuant to 18 U.S.C. 242, meaning this was what was clearly stipulated on black and white, the provision of right under color of law, 42 U.S.C. being the civil equivalent. Listen to this. See docket number 6. The statute does not provide a private right of action and cannot be used in a civil action. And then they even give you a little bit of hint, stating that only the United States' prosecutor can bring a complaint under 18 U.S.C. 241, 242.
So let's just say you know all that and you're just trying to go civil matter. Well, when you ask for damages, whatever type of damages it is, which we went over in this video, which is another thing many people don't know, there are many different types of damages. When you now assert damages, well, they're going to bring about some type of immunity. The question is, what medium are you enforcing that thing called a contract, assuming you did it properly beyond the hype train of just sending something and then saying, you owe me now? Well, that medium is called a declaratory action and an injunctive relief. And in the note of injunctive relief, that brings us to that thing called injunction people do. All those monetary claims in there, right? The reason why you're sending that is because that's what pierces their judicial, prosecutorial, qualified immunity. Injunction is preventative, or if used equitably for the purpose of fixing something that was once done wrong. Declaration goes hand in hand with it to affirm something done privately, publicly. Now the process of collection is another different reality through a supplementary pleading, which most people don't even know they have to do. Again, as I've said a billion times in other videos, they just hear something somewhere, read some PDF, send some document in and go, ha, they owe me. What now? This is what's next. Know what applies, know what does not, and know the medium to which you're doing it. But before you even begin to doing it, or before you begin that, know the thinking behind it and the origin of it. Because they're not just going to lay down and go, oh, yeah, you got us. Oops, our bad. No, they're not going to do that. You will have to know what you're going to present, because all that is just a tender and presentment. Part of that is part of the res judicata. And if you don't know the thinking behind this stuff you're just citing on a piece of paper, it's useless, because it will be challenged to the point where they will blatantly present falsehood in your face and say, you don't know what you're going on about. You should get to a point where all you simply do is cite the case law and you're able to present the principle behind it as facts behind your case and how it applies to yours. Most people never get there because they're even afraid of suing in the first place. The reason why they're going around sending all those papers saying, hey, you owe me money because I send you some document, is because they don't want to sue. But they don't realize that what they're doing privately through mail carriers are stepping stones to suing. What people are ultimately running from is competency. Because if they were competent, they would not be afraid and try to seek a million other speculative la la land methods. If that doesn't sound too good to your ears, then don't worry. You just keep doing the same thing you're doing. All these SPC groups, keep going up there, keep doing that, see where it takes you. And then come back to this video later. Even though it might be too late at that point, and your will might have really died down and dissolved. It's not that most people are not being done wrong out here. They are. They really, truly are. But they've been misled when their fire is still burning very bright, very tall, and very hot. By the time they find the right thing, they're burned out. There's barely no ember at all to even add some other flammable matter to rejuvenate the flame. It's just dead, cold charcoal. And there's no fuel around. So I implore you, No matter how much what I'm saying might sound a bit contrary to the sweet stuff you want to hear, you better wake up to reality and realize that there's a method to the madness called right. There's a method to how everything works. And those buzzwords you're hearing, these things are the origin of it. And you must know the thinking behind it to be able to enforce it. Rather than just following someone who is a follower of someone else, pretending to talk sharp and smart in front of you to woo you, just so you could remain a victim perpetually. Up to you. Allen sued Pulliam in district court and sought declaratory and injunctive relief for incarcerating him while waiting for trial on non-jailable offenses. Jesse Nicholson was arrested 4 times in 2 months period for public intoxication, a class 4 misdemeanor, for which the maximum penalty is $100 fine. Like Allen, Nicholson was incarcerated for failure to make bail, and he intervened in Allen's suit as a party plaintiff. Interested party, because he experienced similar circumstance under similar jurisdiction, under the same hands of the same magistrate. The district court held that Pulliam's practice of incarcerating persons for not making bail on non-jailable offenses violated their rights to due process, aka procedural due process, and equal protection. This equal protection, they're referring to 14th Amendment. The district court enjoined the practices and found Allen and Nicholson entitled to cost. Isn't this what a lot of people are looking for? Even though with judicial and prosecutorial immunity, you can't gain damages, but there's a way you can still cost them. It's called declaratory action, or affirmation of what you've done privately. That's what most people are looking for, but they are afraid of suing. They are afraid of suing because they don't know the standard, test, and elements to their claim. Those things you're sending privately through those notices before you send a default judgment, did you embed the standard, test, and element as attached to the Constitution in those letters you're sending? Because that's the only way it's going to be viable to be enforced publicly as a declaratory relief and an injunction for you to prevent similar actions from occurring in the future. Most people don't implement the standard, test, and element of a certain assertion to be declared publicly into those things called administrative process and those default judgment that they're claiming. I'm explaining it to you right here. Don't let the feelings involved in what breaks your bubble of what I'm saying clouds your mind from seeing and hearing the substantive truth and what you should do. Many other videos have been done on standard, test, and element as it is attached to due process, procedural, substantive, and other substantive rights mentioned in the First Amendment and the 9th Amendment. Go watch those videos. This here is now is telling you, look, declaratory relief and an injunction is how you pierce judicial immunity, because even if they assert the fact that, hey, I'm just doing my job, hence judicial immunity, declaratory actions and injunctions are still enforceable, which is the enforcement of that thing that most people say they're doing when it comes to administrative process or allegedly putting people in default. But before you even get to this point, what are the standard, test, and element to your assertions? Ask people that and they can't even tell it to you. But make no doubts, whatever you say you have as a default judgment against someone, it will be tested, and there will be a standard to which it will be viewed, and there will be elements that are the requirements for you to validate those things that you're saying you have as a claim. If you don't know it, you're just still intellectually masturbating. The district court held that Pulliam's practice of incarcerating persons for not making bail on non-jailable offenses violated their rights to due process and equal protection. The district court enjoined the practice and found Allen and Nicholson entitled to costs, including, meaning they were awarded other things when it comes to costs, and that included attorney's fees, and usually there's an act that requires this, satisfaction of fees. Pulliam appealed, magistrate that is, appealed the finding regarding costs and argued that as a judicial officer, she was granted judicial immunity. Right. The District Court of Appeal for the Fourth Circuit rejected the judicial immunity argument and affirmed the district court's decision. And because the magistrate's judicial immunity assertion was shut down, she moved it up to the Supreme Court, therefore giving you the fact of the case And what is the decision that the Supreme Court made? Well, they made it based on a question. Does judicial immunity protect a member of the judiciary acting in her official capacity? Acting in her official capacity. Acting in her official capacity, meaning, hey, I'm just doing my job, therefore, it's all right for me to basically screw you over. Does judicial immunity protect a member of the judiciary acting in her official capacity from paying attorney's fees in civil suit? So this attorney's fees, you can claim it also even if you're not using attorneys. So this attorney's fees, you can claim it also even if you're not using attorneys. We've ran over that on Patreon. And it's the first and the second meeting we ever had on Patreon. I'm not going over that here. Conclusion. The answer was no. Judicial immunity does not protect a member of the judiciary acting in their official capacity from paying attorney's fees in a civil suit. Again, this attorney's fee is not limited to what you think it is by hiring a third party. But in this case, they use an act, a statute, which provides that requirement of attorney's fees. No, Justice Harry A. Blackmun delivered the opinion of the 5-4 majority. The court held that the precedent set by British common law relied on the issuance of writs rather than the imposition of judicial immunity to protect judicial independence, meaning there's a formal document that's supposed to be presented in order to prevent judicial actors or members of the government under the judicial department from being held liable for simply doing their job, rather than just a concept called judicial immunity. The United States never had a doctrine of judicial immunity from prospective relief. The United States never had a doctrine of judicial immunity from prospective relief. This prospective relief is the declaratory relief and the injunction right here. Declaratory and injunctive relief. That's what they're referring to when it comes to prospective relief. Prospective relief, according to 18 U.S.C. 3626 G7. The term, quote, prospective relief means all relief other than compensatory monetary damages. Compensatory is, well, we compensate you for your loss. All relief outside of any loss that you've incurred. That's what prospective relief is. So within that declaratory judgment, this is telling you is part of your relief will be a type of relief called prospective relief. Now this comes in many different forms. They just use that as a blanket term by saying all relief, meaning there's several of them, so long as it's not compensatory monetary damage. We can give you monetary relief. We can charge them a cost, but so long as it's not for the purpose of compensating you for something you've lost. Many people who hear this would really just lose hope because of the strict nature of what they've learned as to how they can seek relief. They might think, well, if I'm not being compensated for my loss, then I'm not gaining anything. Not really. Not really. Again, here's a thumbnail of the video when it comes to the different types of damages, different types of relief you can seek. It's on Patreon. All relief outside of any loss that you've incurred. That's what prospective relief is. Up to you now to go seek that out, because that's an entire lesson of its own, and we're not going to go over that in this video, but nonetheless it's linked to this video. Independent of that video thumbnail shown just now, you can go find it yourself. It's been pointed out to you now. You're being given the direction that, hey, here, that's the way right there. Do your own independent research. Use your own independent thought. At least you can't say if someone is not pointing you towards the direction of the medium you're going to enforce these things that you ever so desire. Prospective relief is defined as, quote, all other relief other than compensatory money damages and thus include injunctive relief. Quote, all other relief other than compensatory money damages and thus include injunctive relief. Quote, all other relief other than compensatory money damages and thus include injunctive relief. When you look at that thing called the Bill of Rights, which is your sovereign immunity, you see that I always say that privacy is the core and backbone of it. Privacy, in short, just means to be left alone. To have the right to just be yourself and do what you ought to do privately without being bothered or anyone else intervening in your affairs. Injunctive relief does that. The only way, sadly, that most people know injunctive relief is at law to say, hey, child support, let me go file some quick little form of document in a courthouse to prevent the father from seeing the mother or the mother from seeing the father, just things like that. People use it against one another, but you're supposed to use it equitably against governmental actors also. The medium injunctive reliefs are enforced. It's not clear at this point. It's through a declaratory action. So now that you know what a prospective relief, this term just casually used in the middle of a sentence, now that you know what it means, and keep in mind, you already know that a cost was also awarded to them, and part of that cost awarded to the one seeking a declaratory action and injunctive relief included attorney's fees. And there are other costs that the other party was liable for. This cost that the other party was liable for is that private contract that many people run about by doing that default judgment stuff. And that same prospective relief, aka injunctive relief, declaratory action, the United States never had a doctrine of judicial immunity from prospective relief. See the importance of why we took the time to go over what prospective relief is? Because that thing called judicial immunity, it does not protect them from the angle of injunction and declaratory actions. That is the key. And there was no evidence that the lack of that protection created a chilling effect on judicial independence, so they can do what they want. And you're right to bring injunctive relief and declaratory actions against acting judges or anyone who asserts some type of immunity is pierceable by injunction and declaration. The court held that there was no reason to assume such immunity was necessary. There was no legislative history to indicate that Congress intended to insulate judges from injunctive relief. The Civil Rights Act and their interpretations illustrate that Congress intended all state actors to be subject to such remedies to ensure the protection of 14th Amendment rights, which is the equal rights and protection that I mentioned up there. And keep in mind, the 14th Amendment is not enforceable. Neither is the Civil Rights Act, the subsection 1983, and so on, 42 U.S.C. They're not enforceable by themselves. They require an anchor to Bill of Rights, which we've run over in these videos. So that's the Supreme Court's decision on the fact that this thing called injunction and declaratory action is your key to open the door of that thing that you really desire, which is your privacy and some cost out of their pockets even if they claim judicial immunity, because judicial immunity does not even apply to those two things at all. That's the key many people have been seeking. Now to the rest of the card. That's part of the thing that initiated judicial immunity, which that Pulliam magistrate was trying to assert in the previous case law we just read. This was her thinking and her stance. Another Supreme Court decision. Case number 79. Pearson versus Ray, year 1967. So this case law also speaks of qualified immunity for armed municipal employee as much as it does for acting judges. So here it is for policemen. On appeal, the Court of Appeal held that one respondent police justice had immunity for his judicial act under both subsection 1983 and the state common law. So this first part just told you cops can carry judicial capacities. You know, every time you serve the ticket in the middle of the road, they've just sued you and they just served you the summons. That's equivalent to judicial determination. And that judicial determination is the presumption of guilt before innocence. Otherwise, you would not have been told to sign that thing in the first place. If you were innocent before guilty, that whole thing when it comes to going to your opponent to settle matters first before accusing him, that right there is the highlight of innocence before guilt. But when someone is beginning to summon you to a suit, they're telling you you're assumed to be guilty. Come answer. Because if you were not assumed to be guilty, that summons will not give you the stipulation that, look, if you don't respond within a certain period of time, default judgment will be passed against you. See the similarity of what people are trying to do when they send these private correspondences? They're trying to mimic the normal stuff whereby summons is sent to people and it says on its face, look, you got to respond within 60 or 90 days depending on the jurisdiction. Otherwise, a default judgment may be entered. And that act on a traffic level when cops write you those tickets is a judicial act of assuming you're guilty. Someone brought a suit against them and they said, look, even if you sue them under 42 U.S.C. 1983, they're immune from it. And two, that act is a judicial one. Two, the policeman had immunity under the state common law of false arrest if they had probable cause to believe whatever the situation they're asserting here was valid. So the elements of probable cause, you must know it, which we went over in these videos. They were not required to predict what laws are constitutional, but that by virtue of some case law, they had such immunity under 1983, where the state statute was subsequently declared invalid. Now that's the part where it entertained immunity of cops. Now let's go to the one of acting judges, which was entertained in this case. Few doctrines were more solidly established at common law than the immunity of judges from liability for damages for acts committed within their judicial jurisdiction. Within their judicial jurisdiction, meaning while they are at work, just doing their job. Right. As this court recognized when it adopted the doctrine at Brady versus Fisher in the year 1872. See what I mean when it says this is one of the doctrines that gave rise to judicial immunity? The reason why I'm not going over this case law in 1872 is it's a bit more murky. And some of the applicabilities in the 1800s compared to now have really been updated when it comes to state common law in certain languages. So 1967, which is this Pearson versus Ray, is the more common one, but it acknowledges prior case law almost 100 years before it. This immunity applies even when the judge, now this is the part that I want to highlight, which that Pulliam lady in that previous case law that we just read, where she was held liable against prospective relief, aka injunctive or declaratory relief, She was trying to say, look, I'm immune because I was just doing my job. This is her state of mind. This immunity applies even when the judge is accused of acting maliciously and corruptly. That was her state of mind, that look, I can do no wrong, even if you show and say that I'm malicious and corrupt. What is the first thing that comes out of this everyday man and woman when they say something is done wrong to them in these venues? Oh, they're malicious, they're corrupt. Okay, yeah, you're not wrong. You really aren't wrong. They are. But the question is, how will you hold them liable? When you try to explain these things to people, especially over the phone, they're so carried away with their own feelings over the phone that you just can't help but just sit there and just listen to them and go, look, by the time they're done talking, you've even forgotten about what you want to tell them, and you just spend most of the time listening to them expressing their anger. They effectively waste their time to hear the relief that they really want to seek. Hence, videos like these are made so that time could be committed to explain it. The immunity applies even when the judge is accused of acting maliciously and corruptly. And it is, quote, not for protection or benefit of a malicious or corrupt judge, but for the benefit of the public, whose interest it is that the judges should be at liberty to exercise their functions with independence and without fear of consequence. But in truth, the public, you, the everyday man, are the ones they're fucking over. So unless you begin to speak of via certain reliefs, only then will it be enforced. Because you're saying through those injunction, which is a preventative means, that, look, I want you to stop doing this and I want you to leave me alone because I don't approve this. Once enough of that is done and is established publicly, only then can this doctrine die. If enough people don't use injunctive and declaratory relief publicly, rather than trying to run away behind closed doors using some papers in the mail somewhere, which is good, but it does not end there, because they're using your power to say that, well, we're protecting you, the general people, you, the public. Well, you, the public, have to come out publicly to say, we don't want you to. And the stepping stone to that are these prospective reliefs, injunctions, and declarations, and declaratory relief. Declaratory reliefs are called declaratory because they're declarations. The only reason why that Bill of Rights or that Constitution exists is because of Declaration of Independence. Unless you create an injunction, aka an independence, through declaration, this thing called judicial immunity will not go anywhere. Because ultimately, the source of its power is you. Because the intent of that immunity, even when they're acting malicious and corrupt, is not for the protection or benefit of malicious or corrupt judges, but for the benefit of the people, whose interest it is that the judge should be at liberty to exercise their function with independence and without fear of consequence. So they're always using you to screw you over until you speak up. But you cannot speak up if you don't know the why and how and the thinking behind things. These are the why and how and the thinking behind these things that has been shown to you. At least you can say if someone is not telling you. Now going back to that same res judicata, Pulliam versus Allen, which tells you, look, injunctions and declarations are the ways that you bypass sovereign immunity. I always tell you, where there is a problem, there's always a solution. Always. You've established the fact that it's a Supreme Court case, and case number is 82-1432. Opinion and dissent. Judicial immunity, which you've just read, the thinking behind it, where it came from, and why it exists. Judicial immunity is not a bar to prospective injunctive relief against a judicial officer, such as petitioner, acting in her judicial capacity. Remember, the petitioner is Pulliam, which is the acting judge, because she lost an injunctive and declaratory relief to Allen at a lower court. So now she's petitioning to the Supreme Court that, look, I have judicial immunity, and the Supreme Court is saying, no, not really. The other courts are right. Why? Because judicial immunity is not a bar to prospective injunctive relief. The injunctive relief that guy won, your judicial immunity does not bar it against you, the judicial officer, aka such as a petitioner. You, the officer, the petitioner, is Pulliam, acting in her judicial capacity. Common law principles of judicial immunity were incorporated into United States judicial system and should not be abrogated absent clear legislative intent to do so. And those clear legislative intent to abrogate this thing called judicial immunity is in the state compiled statute that deals with declaration and injunction. Each state has something in their compiled statute that explains to you in excellent details of injunctive relief and declaratory action. They all do. And it exists on a federal level also. Common law principles of judicial immunity were incorporated into the United States judicial system and should not be abrogated absent clear legislative intent to do so. Although there were no injunction against common law judges, there is a common law parallel to the 1983 injunction at issue here in the collateral prospective relief available against judges through the use of King's prerogative writs in England. In other words, injunction is a type of writ, and the medium to which you execute that constitutionally secured right, which is the reason and the facts behind that writ that you're bringing up, that medium that you're enforcing it, is the 1983. And therefore you are wielding the power of a king through a prerogative writ. Prerogative is a right based on what you are entitled to, your sense of entitlement. Isn't this what a lot of people want when they say that they are the sovereign? Right, that is true, but you are only the sovereign if you know the means to enforce that sovereignty. Not just claim the crap. Claiming a status or saying you're something is irrelevant. If crunch time comes and you don't know how to enforce it, you can have all the physique of any given sport, say rugby. You can have the physique of a rugby player and all that. You can talk all the shit because you look the part. But get on the field with other people who have similar physique as you and it's game time and they're ready to break your damn neck and you don't know how to do shit, you be fucked up. That is the same applicability with all this pen and paper stuff with most people saying that they're SBC, that they're sovereigns, or that they're sending some paper. Oh yeah, they're in default. But when you start to look at their document, you realize that pen and paper game is weak. It's weak because they don't even know the standard element test to what they're speaking of. Therefore, how can they even ever know the means to enforce it? Because if they knew the standard test and element, there will be a natural development for them to realize, oh, so the way that I'm supposed to enforce the standard test and element of this constitutional right is called a writ. It's called a declaratory relief. It's called an injunctive relief. I see. Because these rights have standard test and elements. And just like these rights came up, there was a declaration, which is called Declaration of Independence. And there's a similitude as to the enforcement of these same rights that came out of Declaration of Independence, which is my declaratory relief. It's a similitude of the same thing that's being done a long time ago. There's nothing new under the sun. Just like the Declaration of Independence was because someone wanted an injunctive relief to be separate and independent of another type of body politic who was claiming some type of immunity against them. They wanted to separate themselves. Well, the core and privacy of those Bill of Rights, which came out of the Declaration of Independence, is enforced through a declaration and an injunction, a separation, a prevention of someone from abrogating you. And you declare it publicly. It's that simple. But most people are running away from that. They're just trying to send some paper and just say, aha, that's it. Why then would some bar members who create some group somewhere, why wouldn't they make fun of you that you're a sovereign citizen? They're making fun of you because they know that you don't know how to enforce your rights. That's the part that I don't like. That's the reason why I don't take sides with anyone. That's the reason why I tell you, look, there's a reason why others are able to make fun of you, because you don't get the clear picture. And here's the clear picture. Someone who cares about you will speak to you this way and tell you the reality and show you the reality outside of some conjecture of how you feel or how I feel. These are the substance behind it. These are the thinking behind it. These are the origin behind it. This is the why, this is the how, and this is the enforceability. Again, there's a common law parallel to the 1983, subsection 1983, 42 U.S.C., which is the medium, which is some of the claims you'll be asserting. Parallel to the 1983 injunction, they're telling you that this 42 U.S.C. 1983, you can bring injunctive relief through it. They're telling you that this 42 U.S.C. 1983, you can bring injunctive relief through it. At issue here, which is exactly what Allen did, which caused Pulliam to want to then bring it to a Supreme Court case to say, hey, I have judicial immunity. And the court is saying, look, there's a common law parallel to the 1983 injunction at issue here in the collateral prospective relief. This prospective relief is the injunction and declaratory action available against judges, through the use of the king's prospective writ in England. You're taking the same power of a king when you enforce injunction or declaratory action. The same power of a king through a declaratory action is what was used for Declaration of Independence, which gave rise to the Bill of Rights, which is the core and backbone of Section 1983. The same power of the king was what was done when the Boston Tea Party separated themselves from some government in another continent. In today's world, the everyday man calls it an injunction, but they're stuck doing that against themselves by fighting and bickering amongst one another rather than using it the proper way that it's meant to be done. That's the problem. Ultimately, when you really think about it, from right to left, from left to right, no matter how shallow, no matter how deep you think of it, the problem is always the people, because the people are stuck arguing against themselves. When you look at most people who deal with all this special information, most of them are stuck on politics. They're stuck on some face of someone in red or some blue tie in some party, this party, that. How about you fix yourself and you start to organize yourself by comprehending the foundational principle that governs you? At the end of the day, all those politics on social media and TV, they're not going to speak about Constitution and tell you this is what you got to do. They're going to keep you distracted. So all that fuel you have, you're going to be using it busy hating someone on some pixel screen who's a multi-millionaire, who does not qualify for tax and effectively avoids the user trust, while you're still speculating on trust manner by doing some crap on some social media group running a circle. You better focus on using what power you have properly rather than focusing on the wrong thing. The problem is always the people themselves, because if the house internally is not broken, no one can shatter it from the outside. If there's no crack in the walls of your castle, the draft of the winds cannot come in. When two brothers are busy fighting one another, another man will come and take their land. Those same basic repetitive principle is the issue that everyday man has been facing and is still facing when it comes to what they consider what rightfully belongs to them, one way or another, corporal or incorporeal. The history of these writs discloses that the common law rule of judicial immunity did not include immunity from prospective collateral relief. That the common law rule of judicial immunity did not include immunity from prospective collateral relief. The history of judicial immunity in the United States is fully consistent with the common law experience. There never has been a rule of absolute immunity from prospective relief, and there is no evidence that the absence of that immunity has had a chilling effect in judicial independence. Limitation on obtaining equitable relief. Limitation on obtaining equitable relief. Limitation on obtaining equitable relief. Limitations on obtaining equitable relief. Isn't equity what everyone is seeking after? Just throwing that buzzword equity about? Listen, limitation on equitable relief serves to curtail or prevent harassment of judges through suits against them by disgruntled litigants. In other words, these acting judges use equity also. Are you? Because writs are in the realm of equity. And one of those equitable writs are injunctions, are declaratory actions. And the means to which you enforce those writs, the medium to which you enforce them, is called 42 U.S.C. 1983. And 42 U.S.C. 1983 does not stand in itself unless you use the Bill of Rights, aka the Constitution, aka your sovereign immunity. Do you see how all these tie together? Collateral injunctive relief, aka your equitable writ, against a judge, particularly when the relief is available through 1983, also raises a concern relating to the proper functioning of federal-state relations. But that concern has been addressed directly as a matter of comity and federalism. These are certain principles of separation of power, independent of principles of judicial immunity. So judicial immunity does not have the grander scale and power of independence as federalism and comity. While there is a need for restraint by federal courts called upon to enjoy actions of state judicial officers, there is no support for conclusion that Congress, state officers now, and that is the hand of where most people get their grief. There is no support for a conclusion that Congress intended to limit the injunctive relief available under 1983 in a way that would prevent federal injunctive relief against a state judge. Rather, Congress intended subsection 1983 to be an independent protection for federal rights. See that? These federal rights are the Constitution, the Bill of Rights. And there is nothing to suggest that Congress intended to expand the common law doctrine of judicial immunity to insulate state judges completely from federal collateral review. This federal collateral review is injunction and declaration. Again, are your state compiled statutes that shows injunctions and declaratory actions, because that is where the ultimate key is as to how you enforce that thing you say you have privately as a default judgment. If that thing you say you have privately as a default judgment is founded on the Constitution, because that's what all this revolves around. So ask yourself, you say you have a default judgment, right? Now, good. What are your standard tests and element of the constitutional claims that you're asserting therein? Don't start telling me about your personal opinion of what you think happened. What are the standard tests and elements of the constitutional claims that you're asserting within that first notice, second notice, third notice, and that default judgment that you said you've sent? And that fee schedule you said you've sent? Are you using a rule of evidence, self-authentication? Are you? Because that's the only way that fee schedule will be admissible. And you must bring the matter publicly. Your personal feelings are irrelevant in all this equation. Principles are the key to how this world works. You must realize that just because someone who is screwing you over is using it also does not mean you should run away from it. All that's merely been done is the power that you rightfully have. It's being used against you. How about you wield it also? Don't wield it through bandwagoning of getting lost in the social element that humans always put into consideration of everything. Don't get lost in bandwagoning of feeling socially secured because everyone else is doing it. Use your independent thought process. Know the thinking behind the thing on their end as to why they're saying they are not liable, which would always lead you to how you can make them liable. A word is enough for the wise. Everything else subsequent to this, we'll be going over injunctive relief and declaratory actions in state legislatures. All that will be on Patreon. Until next time, take care. Best of luck.